Welcome all to the Hines webinar/podcast series, our regular deep dive into the weird and wonderful world of strata management rights in Queensland. My name is Chris Hines. I'm Director of StrataSolve. That's stratasolve.com.au. And as always, I'm joined by Frank Higginson, partner at Hines Legal, the premier provider of legal advice to the strata industry in Queensland. Frank, welcome.
Hello, Chris. And we have a little invited guest today sitting, I think, in the middle between us, which will be really interesting because that's really exciting.
Yeah, it will be. We will introduce that special guest in a moment. Frank, how has the week that was been?
Mate, the
COVID
COVID recovery's been good. So on the flip side of being crook. So as always, you don't know, I suppose, in a sense, what you're missing until you're missing it. So the ability to bounce around and be out in public again has been great.
All those people. Just a reminder for everyone listening in live at YouTube, you can post your queries in the chat and we'll try and get to those and we'll endeavour to answer as many of them as we can. For those listening in later on via on a podcast while you're walking the dog or washing the dishes or whatever, you can find all of the notes and links that we referred to today at hineslegal.com.au. All right, we've been very rude not to introduce our special guest this week. We often talk about the Commissioner's Office and adjudication. I think probably Frank every week we might mention it in either directly or indirectly. Today we have an actual former adjudicator with us, so a real life adjudicator, to get an overview of the mysterious world of adjudication and some tips about how to get adjudication right. So Sean Barry, welcome.
Good morning, gentlemen.
Great voice for radio too. Listen to him.
Yeah.
I won't do the obvious rose between two thorns.
Yeah, sometimes obvious is good. Before we sort of get into the adjudication specific stuff, Sean, you've had a pretty diverse background, haven't you?
Yeah, I don't know whether that means I never settle or whether a solicitor I ran to recently said to me that he likes the way I remake myself. I don't know what that means exactly, but yeah, I was a Queensland police officer for 12 and a half years, and then I went to the bar. So my legal practice was a variety of things. There was a lot of criminal work, lots of jury trials, and then I was appointed a member of the the Police Misconduct Tribunal, as it then was, and then I was taken across to QCAT. So I did sessional work at QCAT for a couple of years, 3 or 4 days a week sometimes. So I did over 1,000 minor civil disputes at QCAT. I euphemistically used to call them Judge Judy events. I don't mean that we were like Judge Judy, but it is like that, where there are people who are impassioned by their case, and you have to find a path through that. And then I ended up at the I for some reason decided I wanted to be an academic, so I did a thesis in political science, which didn't lead me to being an academic, and then I ended up at the Commissioner's Office for 2.5 years. I decided to, because I wanted to chase some warmer weather, we moved to Tasmania, so I have the title of Assistant Director, Compliance and Dispute Resolution, Consumer Building and Occupational Services in the Department of Justice down here. There you go. So I've got 2 teams I'm in Launceston, they're in Hobart, but one of them looks after residential and tenancy matters in Tasmania, and short stay, actually, because we report on short stay down here. Mm-hmm. And also the other team looks after consumer matters, incorporated associations and charities, and I'm about to start a new team to look after compliance and audits about these things around the state. So that's it.
Jeez, that's diverse. All right, so Sean, I know I often bang on and on and on about how unique the Commissioner's Office is in the world. It's literally not replicated elsewhere. What do you reckon the pros and cons of that are?
In short, I think the biggest plus is specialisation. Now, that can lead to blinkers as well. I understand that in the world generally, but There are 7 adjudicators in Queensland, coming or going. There are 7 positions, and that's all there is for the 50,000 schemes. They're skilled. Do they always get everything right? Did I always get everything right? Well, that's for others to judge, but they are skilled. They're underpaid. And I've got enormous respect for them, all of them. And they all bring something, to use a cliche, to the table of this sort of work. And I think they're undervalued, actually, sometimes by various parts of the community. But that's just my view. I can say that now. I don't have the official Secrets Act of the UK to tie me down. But I've got great respect for them. But
I might throw it to you, Frank. You're a practitioner, and your work is in front of adjudicators on a pretty regular basis. I mean, what's your take on it from that perspective?
I think it remains completely unique, and I suppose, Sean, if you go back to QCAT, you're running 1,000 different, like QCAT, I suppose, is the repository for a bucket load of pieces of legislation and disputes about legislation. So in that sense, you're almost, as a member of QCAT, a general practitioner. And probably it's a bit like what we do as a business, Chris. I think, all we do is Strata stuff. And the more you delve into it, the more you realize how specialized it is. So that commissioner's office element, and I suppose as a practitioner, when something goes in there, you're going to be in front of someone who absolutely understands what the legal issues are. Whereas if you took a body corporate dispute to the magistrates court, and with all due respect to magistrates, they also have a bucket load of different pieces of legislation that are going to appear in front of, not the least of which is criminal and civil matters to start with. Like the criminal code itself is a beast. You put a strata specific dispute in front of a magistrate, and for those that aren't familiar with it, they're going to probably be more at sea than they might be with a criminal matter. So that, from a practitioner's perspective, I think it's a magnificent resource. We've got to resolve strata disputes because it is that specialisation that makes a difference. You're not going to get someone who's guessing.
The other thing I was going to say about it too is that even though it's an entity of the public service, and that has its limitations too, which I'll talk about. But the biggest positive, I saw when I was there, Chris was the commissioner when I started, and the Michelle who followed, there is absolutely nothing. They will have nothing to do with the adjudicators apart from approving leave or something. Nothing. They leave. The adjudicators are kept quite separate to the rest of the office, and you are independent. I was never under any pressure to make any sort of decision that was different to what I saw the facts and the law to be. And I mean that. It is, no matter what some conspiracy theorists think in the things they write that come to the office, I can assure anybody that that's just not the case.
And I can add that from my and Sean, to pick up on that point, there was never it never came from anywhere else either. There was never any minister's office picking up the phone and saying, you will adjudicate this matter this way. It didn't happen.
Yeah. What do you reckon, Sean, then? No, the limitations, really, the downsides. Yeah. We've got the good sides.
Yeah, I think other delays. The biggest one's delay, and that's caused by under-resourcing. And I'll say it. Chris has said it. The community, the SCA has said it. The office is underfunded. And that is the biggest problem for it. To give you an example, there are 7 really skilled adjudicators there who've got lots of life experience and legal experience and policy experience. We couldn't even afford to have a LexisNexis subscription, for instance. So there's no legal research software. They had to find it their own way, going laboriously, going through precedent to find. So there were no shortcuts for research, for instance. So it's actually hard work, and they do well with it. But my point is that until those resources are improved, expect delays. As God made little green apples, that's what's going to happen. I think the low cost nature of the jurisdiction, though, can lead to abuse. So it's good for people who come in with one dispute that they just can't settle. But Chris will know this. There are what I might call frequent flyers who abuse the system and are vexatious litigants, but they can't be declared so. And that was an important issue for me. I can't speak for the other adjudicators, where they just use this system to clog up the decision-making processes of their scheme.
It's interesting you say that, Sean. This week, I posted on recently I posted on social media a link to a recent order from Adjudicator where they made a costs order against the applicant. And the applicant described themselves as a retired legal practitioner in 2 jurisdictions. I can't remember which 2 they were. And it's interesting the reactions and the feedback that's come from that. Just the number of people who have chipped in to say, yes, thank goodness, that's how it should be. It remains an untapped area, I think, that one, for government to sort of look at how that abusive process can be addressed and stopped.
Absolutely. So I suppose then, good and bad, let's get into some of the nitty gritty, mate. What do you reckon people more commonly than not make mistakes when they're making their own applications or responding to applications? So if they're self-represented, where do people, if you're going to tick a couple of dot points, where do people go wrong?
Self-represented or by some lawyers. It's equally open, and that's it, not being clear about what they want. What outcome do they want and why? And this leads probably on to other discussions I might mention later, but filling an application full of irrelevant material and irrelevant events that go back 20 years that are of no interest to the adjudicator whatsoever, but just bog the process down. And the argument might be, how do I know what's relevant and what's relevant? Well, if you're making an application for a dog that's been refused in the scheme, I think it's pretty clear, it's about what's happening now, not what, and there may be arguments about this particular chairperson for 10 years has been persecuting me. Well, maybe they have, but the problem with it is that there are other decision makers in the scheme as well. So you've got to be careful you don't stray away, like I'm doing right now, straying away from the subject that's relevant. And I think that's the other thing is personal attacks, and I've gone on to that, playing the person, not the ball. That's all too common in applications, and the adjudicators just aren't interested. They don't let it influence them, but like everybody, you get sick of having to read through this and getting to the nuts and bolts about what does the Bible say about the dog. What was the decision-making process of the dog that surrounded the dog? Was there a decision-making process at all? Which is often the case. There isn't one. So, yeah, I think that's just staying on track.
I suppose these disputes, we always say they're more emotional. They're not usually commercial disputes. They're not disputes over money. You owe me $100,000. I sue you. We never see each other. We're in the same community, and people have seen each other in the lifts, and that sort of people tend to get emotionally involved. And I suppose that's a byproduct of that. Yeah, we're fighting over a dog, but we've had 5 years of previous issues, and we're going to ventilate all those as well. Watch us go when it's not relevant.
Yeah. No, and I understand that. And I'd be wrong if I said there weren't applications that I felt as well. Goodness me, I can't believe this. This decision was made or it wasn't made, and this is just outrageous. But you've got to put that aside and be dispassionate about the outcome. So I can understand why people who sometimes, well, I've owned in schemes in Queensland, so I understand where people start to lose it. Of course, we're all human.
And Sean, continuing on that theme, what was the most frustrating or annoying part about the role and what you saw?
If amongst, I don't want to get into private conversations, but one of the most frustrating things, and I've touched on it a moment ago, or in the last piece of the discussion, is about applications spiraling out of control. The record one I saw while I was there, one of the other adjudicators had, was 1,500 pages of material, and dozens and dozens and dozens of pages of written submissions. most of which were not relevant. And the problem with that, as you can understand, is, and then he still had to go back and get more information because the information, he needed more relevant information, and that was for a large scheme in the valley. So I can understand what, well, like Frank touched on before, about the emotion of it, about what should be there and what shouldn't be there, and I can come back to that later. But for instance, if you, this is just an example, and this is for me personally, I can't speak for everybody else, but if you're going to refer to the bylaw about pets in the scheme, then refer to it. I don't need the whole CMS. I don't need 30 pages of it or 40 pages of the CMS. And make an offer in the decision, in what you write, your submissions, to say, I can supply that, the full document, if you require it. I heard some people say in the past that lawyers are worried that they won't be able to refer to matters for material at appeal if it's not included in the application. Yeah. Anyway, I don't know about that. The fact is, it may surprise you all to learn, but adjudicators actually have access to title records, and we can look at CMSs and everything else. So we don't necessarily, and we don't always need to be told about our jurisdiction, you know, for page after page. So there are things that become frustrating, and and you flick through it, you move on, but it's probably unnecessary. So I think the size of applications now, they have got larger. They got larger in the time I was there, and I think being PDF, being online lends itself to that, although I have seen some large paper versions as well.
So I suppose, mate, you would have written dozens, hundreds of adjudications throughout your couple of years in there. Did you have a really memorable one, or favourite one, or standout one?
I had plenty that Chris will know upset people, but I was a little strong in my words sometimes. I can think of one particular scheme, and Chris will know which one it is, at the Gold Coast, where there's a common litigant there who didn't like some of the comments that I made about that person, saying that the threats that they'd made to the chairperson in any other way would have constituted likely a criminal offence, and that they should be careful about where they take it. Well, they took exception to that, but of course their words were recorded, they were written down, so in their own emails, so it was hard to deny them. They're like all your children, Frank. Yeah, there were a couple of hundred. It's hard to choose from them. I think that decision, I think I'm losing memory of some of it now. Don't know through PTSD or not, but the decision of Allure, which got a bit of traction around the Strata community, where I
Section 116
voided some motions from a meeting about 5 years before, which effectively took away the management rights of a party, even though in the normal scheme of things, an adjudicator doesn't have jurisdiction to deal with management rights. It was a cleverly written application by the lawyers, framed that way to deal with the decision, and other adjudicators in the past had touched on this, and I followed that precedent. I was keen on following precedent. If you read my decisions, you'll see that there. Others do as well. I like to follow, if there was quality precedent, I would follow it and I'd refer to it. I also like putting pictures in and diagrams, but that upsets some people. But you will see it. My last decision had lots of pictures in it, but so I think that one
actual pictures, not like stick figure drawings, and yeah.
No, because I thought, I mean, the very last, I think it was Crown Towers was the last decision I did, and it was a complicated one because it was about a lot that was in the open area of the foyer, and I thought, how can I explain this? Well, I'll put the pictures in; they were supplied. I mean, what better way? Why don't people put pictures in legal decisions?
It's 1,000 words, isn't it?
Because it does, but it's true. And then put a little bit of the plan in there, so people can go, oh, when you're referring to that, I can see what you mean now and what the parties are arguing about. But everybody's got their own way of doing it. But that was the way I probably that Allure one got a lot of traction. Yeah.
Sorry to interrupt, Sean, but I was just going to say, in an ideal world, the adjudicator would actually go physically to the scheme and look in some cases. And you have the power to do it. That's fine, but resources just don't permit it. Like if there were a fleet of adjudicators or more resources, then you could go and look at these disputed things, and you'd probably get a far better impression of what was going on in some cases.
That's hard to argue with. You'd probably have to take public transport to get there as well. But yeah.
Not the adjudicator mobile. Let's because I know that most people listening are going to want to sort of focus on this bit, but let's leap to the idea of top tips, Sean, for adjudication. So somebody seeking adjudication, what are your tips to make it work, Sean?
Okay, really quickly, I wrote down a quote because I did lose it a little bit with a particular scheme in Queensland, and you guys will know which one I'm talking about, where I wrote on the first page some hints to them about how they might think about dealing with things in the future. It worked for a couple of months. We started applications, but then they started again. And I said this when I finished my terse words. I've only one piece of advice on this occasion. It's time for the aggrieved owners to sit down and sort out their issues. The legislation calls for self-management. This office is a last resort to provide low-cost justice when all else has failed. It is not the first port of call when you do not agree with the actions of the other side. I think that's an important issue. Use conciliation at the Commissioner's office for what it's intended to. Go there with the right spirit. The conciliation office, the manager there is brilliant. The conciliators are brilliant, and they are able to help people settle most matters. But approach that with an open mind. If it comes to pass that you can't do it and you've got to go to conciliation, then I've also written this down because I'm probably getting old. Note these things. Make sure you're clear about what the outcome sought is. Write that down and then put it in front of you while you're thinking about everything else. Flick through the legislation. See if there are any guides out there. Is there any aspect of the legislation in Queensland that hasn't been written about by someone, either as a manager or by a lawyer or by lay people? Plan your application. Simple statement at the outcome, so the adjudicator can look at it and go, that's what they want and why. I want my dog to be in the scheme, and because the bylaw allows it, and they've been unreasonable. Okay, so straight away I know what the application is about, and that helps the adjudicator lead into the material. Dot point your argument in just quickly at the start as well, so that the adjudicator knows where it's going. Write your arguments as concisely as possible, and not in the way I'm using these words today. Refer to them in the documents and tie the document into what you're saying. So if you're referring to bylaw 19 about pets, then refer to it. Don't have these documents attached and the adjudicators trying to work out why they're there, and let them. This will save time and it will speed the process up. Do not write 50 pages of written submissions. That includes lawyers. Just because you can write 50 pages of submissions, the adjudicators don't care. They want you to get to the point. And my biggest tip, I think, is to go to Austlii. If they don't know the website exists, the owners out there and whoever's watching, go to Austlii. It's a free service from a university in New South Wales, and you can actually search for the last 20 years or more, all the adjudicators' decisions. You can see the musings of the adjudicators, so you can understand then what they say about pets, what they say about whatever issue you want to canvas in your application. So you get an idea of the precedent and you get an idea about where their thinking is. You might realise you don't have a case, or you might think I've got a strong case now. These adjudicators said this, so you can always refer to those decisions if you want to. I think it's a great resource, and I don't think it's referred to enough by lay people. You don't have to be a lawyer to read them, and just put some keywords in there. Put pets, whatever. Chris, you can put up a link for Austlii, can't we?
We will put a link that will come up. Yes.
Yeah.
Yes. Yeah.
If those tips help, I hope.
I would think so, Frank. What do you think? From
absolutely,
again,
absolutely. It's probably, and like even I can do legal research on Ostley. So I think if I can do it, it's not that hard. So, but yeah, and I suppose then I think for me, the art in framing an adjudication or responding to one then is because adjudicators have the ability to make an order that's just and equitable in the circumstances. And this is the danger, I suppose, just because there's a decision there that looks supportive for your particular idea doesn't mean that's going to be a done deal. You've still got to make sure you frame your argument to fit whatever the particular circumstances are, because there might be some nuance in that previously decided decision that's different in your case, and that's the thing you come a cropper on. So I mean, that's what
that's a good point.
Yeah, the lawyers, good lawyers do, you know, and it's and that's the thing, this whole area, it's sort of, you know, it's designed for self-management, it's designed for self-resolution, it's designed with this wonderful commissioner's office you ring, and there's a helpline there and all that sort of stuff, and it's supposed to be simple, but it's not. And it's just part of the frustration for me, I think, is that's what the government wants it to do. And there's, you know, 500,000 people owning these units and more living in them, and we should be able to do this, but it's not simple. And I don't think it ever will be. That's this dichotomy, and I don't know how to ventilate that any more than that, but it's not as easy as what people think it might be from time to time.
Yeah.
I remember when I first arrived there being amazed by the number of modules, and I made the comment that there's more modules than there were in the space program to go to the moon. That can be tied up.
Sean, I was speaking to a client very recently, and an issue has emerged for this client where they're sort of thinking about they might have to take it to adjudication, and they were asking me about what that involved, and I sort of talked around it, but the biggest point I made to them is that and I make this point a lot now, you've got to be resilient enough to go through the process. It's one thing to seek justice, to put it in those terms. It's quite another thing to be able to sustain yourself through the rigorous process that you will have to go through. It's 12 months of action, paperwork, thinking, stressing, doing. And you've got to be match fit to do it, basically. And if you're not match fit, there's no point embarking on the process to do it.
Well, they've got to go to Frankton, haven't they?
Yeah, and that's, you know, I think it's, you know, the lawyer who acts for him or herself as a fool for a client, that old chestnut. It's doing it yourself. You're never far enough away from what the issues are to be completely independent about them. You are emotionally invested. And I know the first, you know, we have lawyers act for us when we have legal issues. We don't do it ourselves. Not that, you know, we have too many strata fights, but even simple commercial things like leases or whatever, we get another lawyer to do our work to give us just that element of independence. And I think, you know, when it comes to litigation, which is really what the Commissioner's Office is, like there's a justice system and a legal system, and I think people confuse them as being the same thing, and they're not. So you ultimately might get to a just outcome, but the legal system in the meantime is 12 months of whatever it is, getting to that outcome, and the uncertainty of it is the thing that keeps you up at night.
Yeah, definitely.
Yeah, and the overriding factors of self-management and then self-resolution. I mean, the office will push really hard about what self-resolution you've attempted before you go to the stage of, you know, conciliation and adjudication. So I think that's got to be remembered by people too. It's not a matter just of I don't like that decision. Right, I'm off, and I want an adjudicator to decide. And you do read people say that. It's not that simple.
No. Very, very not that simple.
But, and none of this is to put people off. It's to say, as you both have said about match fitness and so forth, is to say that there are quality decisions coming from quality adjudicators. Under-resourced, I'm going to say it again, quality adjudicators. And I'm a fan of them. I didn't leave for any good reason that I didn't like them or I didn't like the office. So I'm a fan, and I think they do good work. And anything we can do to help them make their lives a little easier is okay with me.
Well said. It's a great note to wrap up on. We have actually come to the end. We could probably have waxed lyrical. Maybe we could wax lyrical again another time. But that is all the time we have for this time around. You can find the notes and links that we've mentioned at hineslegal.com.au. You can find me at stratasolve.com.au. You can find Frank at hineslegal.com.au. You can find Sean in Tasmania. Sean, it's been great. Thank you so much. That's been an excellent insight into a dark and mysterious world.
Yes, mate. Thank you very much.
Thank you, John.
Yeah.
Cool.
Okay, mate.
Thanks, everyone. We'll see you next time.
Bye.
Bye.
See you guys.